Hello and welcome to Parley, the Hindu's weekly podcast, where we explore pressing questions of public interest with insights from leading experts. I'm Aaratrika Bhaumik, your host for today. The question for this week is the 3 year practice requirement for entry level judicial service a viable reform? On May 20th, the Supreme Court effected a seismic change in the recruitment process of the district judiciary by mandating that in order to become a judicial officer in the entry cadre, a candidate must complete at least 3 years of practice in advocacy. This marks a reversal of the position adopted in 2002 when the court had removed this practice requirement, overruling a 1993 judgment that had originally mandated it. To discuss the far reaching implications of this verdict, we have with us today Mr. Prashant Reddy T, lawyer and co author of Tareekh Pe Justice Reforms for India's District Courts, and Mr. Bharat Chugh, an advocate based in Delhi and a former civil judge. I welcome you both to the podcast. Thank you so much for joining us today.
Thank you for having me.
Thank you, Aaratrika.
Mr. Reddy, if I may begin with you, in your book, you have pointed out that entry level judicial officers often lack practical as well as real life experience. So, are you happy with this reform that the Supreme Court has come up with?
Well, I'm not happy in the sense that yes, I think it's a good idea that they've done away with that they require at least 3 years of practice. But I'm of the view that minimum, I mean, just 3 years is not enough. Judges should ideally have far more experience in office. As practicing as lawyers before they can take over a judicial office, and I can give you the reasons as we continue in this podcast.
Right. And Mr. Chugh, I mean, of course, you've had prior experience in the district judiciary. How do you view this reform?
Well, in the interest of full disclosure for your audience, I mean, I became a judge myself at 23. So, but I'll try answer. So, I'm a beneficiary of the system, so to speak, or as it was earlier. But I'll try to speak, as and try and remove myself from the equation. I'll try to speak not just as somebody who's been a young judge, but also somebody who's trained many of these young judges and worked with them at the academies and as a practicing lawyer. I think this is raises a lot more questions than it answers. I believe, and maybe we can get into these issues as we speak, that a 3 year requirement is not going to make a lot of difference. I don't think 3 years at the bar would have any tangible sort of difference in terms of the exposure of a candidate to law. I think it takes a lot more than that, really. Plus, I think it would have the effect of excluding a lot of people from the current pool of candidates that we have, and would really impede our ability to attract a lot of talent into the system. And the 2002 system, where we did away with the practice requirement, and that was a very well thought out decision by the Supreme Court, had led to a lot of benefits where we were able to attract a lot of young people who are idealistic, who are good at their law, who are good law students and young lawyers into the system, and generally improve the quality of decision making. I think this decision to introduce a 3 year mandatory practice requirement is not based on any empirical data or evidence as such, which would show that without the practice experience, the judicial officers have been wanting in some respect or the other. So I believe on the whole, it raises far more questions than it answers, and I don't think it's really a solution to the concerns.
Right. Mr. Reddy, I would like you to respond to the contentions that Mr. Chugh raised. Primarily, first, that do you think it's an exclusionary measure? And second, being, I mean, he raises a very important point that if you look at the judgment, what the bench has relied on are the subjective opinions of the High Court, of the High Courts. There hasn't really been any empirical study to see if judicial officers without prior experience, practical experience, face more complaints or disciplinary actions compared to those without such experience. So, how would you really view these criticisms?
Okay, if I can start with your second question first. uh, the views of high courts is also empirical evidence, right? And except for two high courts, all the high courts were of the opinion that this experiment with getting young lawyers, young law graduates to join the bar, the bench has been a disaster, and it's not just the high courts. In 2021, the Bar Council put out a scathing press release attacking this very issue, of young law graduates joining the bench without any experience. I'll just quote two lines from that press release in 2021, where the BCI said, judicial officers not having practical experience at the bar are mostly found to be incapable and inept in handling matters. Most of such officers are found impolite and impractical in their behavior with the members of the bar and litigants. So, when you have a majority of the high courts, an overwhelming majority of the high courts, and the Bar Council of India saying almost the same thing based on their experiences handling complaints and appearing before these young judges, that in my opinion is sufficient empirical evidence to make a policy decision. So I'm not sure why, and this is not just Bharat, but I've heard even other people say that there is no empirical evidence. There is empirical evidence. This is empirical evidence from people dealing with the system. You could argue that it could have been designed, they could have conducted a scientific, early designed survey, etc. But we can't discount all these opinions. Now, coming to your first question, which is, will this be an exclusionary measure? Now, there we suspect that yes, it might impact the number of women who join the legal profession, because if they have to practice for 3 years and then write the exam and join the bench, the likelihood of a lot of them dropping out is going to be high. And that's the view that a lot of us have with this 3-year practice requirement. But what is not being discussed in these same debates is the fact that most states have reservations for women and scheduled caste, scheduled tribe, and even I think some states even have reservations for OBCs. So this is because in every state, the judicial service is modeled on the same lines as the civil service. So whatever reservation quotas apply to the civil service also apply to the judicial services. So that is one way in which you can ensure that the doors are still open for a lot of these, the marginalized sections to join the bench. But in addition to reservation quotas, one of the points that we need to recognize is that the bench is always a reflection of the bar. And if we don't have a diverse enough bench, it's also because we don't have a diverse enough bar. And one of the recommendations that my co author Chitrakshi and me make in this book is that the government needs to leverage its procurement of legal services to open up opportunities for the marginalized sections, for women in government legal services. And that way you help them get a toehold in the legal profession, and you create a more diverse bar, which will then lead to a more diverse bench also.
Right. Thank you, Mr. Reddy. That's quite insightful. But I would also like to pick your brain on the fact that, of course, we have a practice requirement now, and your opinion is that it was essential to have better reasoned judgments coming out from the district court. But do you think there should also be reforms when it comes to judicial training of these officers? That has to be made a priority too.
See, subject to what Bharat says about his experience at the Delhi Judicial Academy, uh, I have done a study previously about 5 6 years ago, and our general view in that study was, after speaking to some of the judges who had been trained in these academies, is that judicial academies are woefully under equipped to train judges. It's just they don't have the resources. And also, you need to understand that, all of us who have studied in law schools in India know that these clinical training programs that we have, where young law graduates are to get certain advocacy skills in a university setting, these programs have been woefully inadequate, because it is fundamentally very difficult to give these kind of real life skills in a classroom setting, and the judicial academies are going to struggle to do so even if they are well equipped, because you need like faculty to student ratio of almost 1 is to 1 to ensure that you can give that kind of feedback and training. But what also cannot be captured in a judicial academy setting are life experiences, right? There is a vast amount of difference in how you perceive the world as a young adult, who's just graduated college at 22 and 23, and how you would perceive life as a 35-year-old or as a 40-year-old, because you have gone through so much more in those 10 years. A lot of you will get married, have children, you have to manage a household, you have to go around, looking for rental accommodation. These are all experiences that completely transform the way people look at life, like dealing with a boss, dealing with a difficult boss. So these kind of experiences give you a certain amount of emotional maturity, and that's been one of the complaints of a lot of these high courts. Like the Uttarakhand High Court had specifically complained. They said, moreover, judging is a serious task and requires some maturity of thinking and experience of life. This was in their feedback to the Supreme Court's committee which was studying this issue. So we also need to factor this in, that emotional maturity is as important as knowledge of the law when it comes to judging from the bench.
Right. Mr. Chuk, drawing from your experience, do you think the training that the entry level cadre they undergo, is it sufficient to make them competent adjudicators? And if you could also address what Mr. Reddy pointed out, that we do have reservation when it comes to women as well as those belonging to marginalized communities, so that there is no accessibility problem per se.
Right. Let me just first quickly address, what Prashant said, and I agree with him that in something such as judging, where you have to appreciate two sides of the story, and law always operates in a social context. Your understanding of life, your experiences, your ability to deal with people, your understanding of human behavior, and the motivations and incentives of people will always be extremely helpful, in judging, and in fact even for lawyering for that matter, right? When we argue cases, we are not doing so in a vacuum. We work with in a social context, and understanding of life definitely makes you a good lawyer or a judge. So there's absolutely no denying that. And much of this, I agree also, that cannot be taught within a matter of 1 year of training at the judicial academies. Now judicial academies try to do a lot in terms of having simulation exercises where real life scenarios are played out for the judges to be trained with, and it's a very extensive training at some of the academies. But again, yes, it is not a substitute for life, that I completely agree with. But please appreciate this. Now if you really want to have experienced people doing the judging even at the entry level, then you'll have to make the service a lot more attractive than it currently is. Now picture this. Now if a normal law graduates at the age of 23 or 24, and now has to spend the next 3 years have gaining the experience at the bar, because it's a precondition now to the exam, and then the exam process takes another 2 3 years before person finally dons the bench as a civil judge or a magistrate, then you've taken the candidate already to an age of about 28, 29, or 30. Now with the present work conditions and everything that comes with it, is it an attractive career option for a 30-year-old to be starting off as an entry level magistrate or a civil judge? Especially when merely after 7 years of bar experience, and maybe with the age of 32, 33, or 35, you can straight away take the district judge exam. So my argument is this, and obviously this needs to be thought through in a lot of ways. Would we be able to attract a lot of good talent at the entry level if they have other alternatives in terms of a successful practice at the bar, or they can take the district judge exam? How do we attract people, and how do we make the service attractive, is a question that's unanswered. And also there is, and this must be stated, that when a entry level judge joins in, and I can say this from experience, normally at the very start, so for instance, and a 23-year-old judge, by the way, that figure is a little attractive, to attack, and it's a little shocking too. But that's an exception, not the rule. Let me say that that's not the average age by which people enter the service. It's a bit of an outlier, that age. An average age and maybe Prashant can come in on that. He's researched this far deeper than I have. Maybe a 26 or a 27 or in that range. And where, when a judge enters the system initially after taking the exam, you are initially given assignments such as, for instance, a check dishonor court. For example, where the offenses are bailable in nature, where your ability to, in fact, even send somebody to judicial custody is restrained a great deal. For instance, in Delhi, for the longest time, new judges were not given the proper criminal courts in terms of police stations, but were given special assignments, quasi criminal, quasi civil sort of cases, where even if you are sentencing somebody at the end of a trial for 2 years, you have to suspend the sentence and you don't send the person to jail and allow them to file an appeal. And on the civil side of things, the new judge's jurisdiction was restrained, with pecuniary limits. For example, in Delhi, I don't think a civil judge can decide a case of more than 3 lakhs at the moment or at one time. So that's these limits on a young judge's jurisdiction are also there to ensure that they gain experience and then go on to decide cases which have a greater impact on personal liberty and life, and in the meanwhile gather those skills. And by the time they really get some of these positions of authority, they are already 5 years, 4 years, and if you want to do a sessions trial, 12, 13 years into the system. So the kind of energy, idealism, technocracy, being abreast of the new laws, the kind of talent that you're able to attract by having young people take the exam. And sometimes, let me say this by experience, that's the only way in which somebody who does not have the social capital that is needed to get into practice of law can really make a mark. It is a big equalizer in that sense. And that opportunity, especially for underprivileged, the women, first generation lawyers, is extremely good, and they are able to take that responsibility. And it's always, one point in favor of young judges also is that you can mold them in a certain way. The life of a judge or an adjudicating function is sometimes very, very different from the function of a lawyer and the persuasion of advocacy. And these are two career paths. If somebody has chosen to be a judge, and there are so many people who just want to do this, they don't want to practice law as an advocate, then they should not be excluded from exploring that because of this requirement. So that's basically on the major part and the first part of what Prashant said. On the issue of reservation, I think yes, there are some reservations in state judicial exams across the country. But again, with now there being a 3 years practice requirement, you'd still have that as a mandatory condition. And for instance, somebody has a reservation that they can avail, they'll still have to put in those 3 years, which may be very, very difficult for some people to do. For example, this the guidelines or the Bar Council of India circular, there is good reason behind that. But a reality that also needs to be taken into account is that what is it that we are providing the young people entering the practice of law? If you don't have the social capital, if you don't have a great law school behind your name or on your CV, the people are not even making minimum wages. People are not being given a basic stipend. And now somebody who always wanted to be a judge would have to spend 3 years mandatorily just to be able to take the exam with absolutely no, basic social security in that sense.
Thank you, Mr. Chugh. We'll discuss whether the district judiciary will still attract top talent in a bit. Before we discuss that, Mr. Reddy, could you respond to what Mr. Chugh said? Primarily, first, that do you think that the fact that these young judges, their jurisdiction is limited in terms, I mean, the pecuniary jurisdiction, like Mr. Chugh mentioned, is limited. It's some sort of insulation of sorts. And second, he makes an interesting point about the age, because in a lot of states, the upper age limit for the general category candidates is, let's say, 30, 32. So, does the practice requirement kind of reduce the window for preparation as well? Because, especially when it comes to, let's say, candidates who have done a 3 LLB course after their graduation degree. So, do you think it kind of disproportionately affects them?
See when you're framing a public policy question such as this qualification requirement for judges, your primary objective is to get the best people on the bench who can do the job. Personal aspirations, diversity, etc., are secondary objectives, which will you can factor in later once you agreed on the baseline of what is necessary to join the bench. Now, for example, you've raised this question of upper age limit. We need to stop for a minute and ask ourselves, why do we have an upper age limit for judicial office? This is not there in any other country. Like, I can understand if you have an upper age limit like retirement age, where you're worried about a person's senile, whether a person is senile enough to hold office. But this upper age limit for judicial office at this age, which is 30, 32 years, it makes no sense. What are we trying to achieve with it? This, like, an upper age limit makes sense only for the army, the police, where you need physically fit people. When it comes to judging, you actually want more experienced people on the bench. And there's no purpose served by having an upper age limit. And if I can slightly reframe this debate, if you look at the qualification requirements for district judges and high court judges, right, as per the Constitution says 10 years practice requirement for an advocate to qualify as a High Court judge. And it says 7-year practice requirement for a district judge to qualify, for a lawyer to qualify for the post of district judge. But in reality, what happens is a practicing lawyer is rarely ever considered for the post of a high court judge until they are minimum 45 years, and the average is closer to 50 years. So basically, you're going over and above what the constitutional requirement is. And similarly, for district judges, despite 7 years being the minimum practice requirement, which most lawyers will hit by the time they're 30 years, the minimum age requirement in most states is 35 years to qualify for the post of a district judge. And the actual age of appointment, we have data from two states, Madhya Pradesh and Karnataka. In Madhya Pradesh, it's 44 years at the average age at which lawyers are appointed to the post of the district judge. And for Karnataka, it was close to 50 years. So the job of a district judge now is not very different from what a judicial magistrate has to do. In fact, a judicial magistrate has a more onerous responsibility because he's dealing with a lot of remand requests by the police for people from marginalized sections who usually don't have a lawyer representing them in court. He has to make crucial determinations of as to the liberty of a person, right? So if we are insisting on a de facto 20-year practice requirement for district judges, why are we happy with just a 3-year practice requirement for a judicial magistrate? And look at other countries. The United States, in the federal judiciary of the United States, the lowest rung is the magistrate judge. The law over there says practice requirement of 5 years. The average practice experience that most lawyers have by the time they're appointed to this office is about 22 to 23 years. The average age of appointment is 50 years, which is the same age at which their incumbent Chief Justice has been appointed in the US. Chief Justice Roberts was appointed in 2005 when he was just a 50-year-old man. So this is how, like, this discrepancy, like, why are we okay with having a 20-year practice requirement for district judge and a 3-year practice requirement for a chief judicial magistrate? It makes absolutely no sense. A lot of this is because of our colonial baggage, where the district judiciary was not even viewed as a judicial office in the conventional sense. It was entirely modeled on the lines of the civil bureaucracy, and the lot of the qualification requirement was mindlessly created. This 3-year practice requirement actually goes back to the 19th century. It was in 1993 when the first All India judges case, looked at the issue. They basically did not do a proper study. They said, okay, 3-year practice. They just made 3-year practice requirement mandatory across the board. In 2002, when the second All India judges case came out, there was again no study. It was just, in one paragraph, the judges decided, let's do this practice requirement, we'll create judicial academies. And this is also a poor commentary on how the Supreme Court has dealt with these issues. And similarly, the recent judgment that we are discussing today, if you read it, there is no question of law being decided in it. It is complete. It reads like a policy document where they've just documented the views of the high courts, and they have said, okay, now let's bring back this 3-year requirement without assessing whether a 3-year requirement is going to do the job. This is what Supreme Court judges don't seem to understand, that these kind of policy issues should not be decided in the courtroom. They need to be decided outside. There needs to be a comment process, public participation, etc., so that you can come out with a well formulated policy.
Mr. Chuk, I'd like you to come in here. Do you think that there should be parity when it comes to the practice requirement? Because, like Mr. Reddy mentioned, for district judges, the requirement is 7 years, whereas for civil judges, it's 3 years now. So, there should. Do you think there should be parity when it comes to these requirements? I mean, like you mentioned, most importantly, that I mean, civil judges are often the first line of defenders when it comes to personal liberty.
Right. So the judges or trial judges being the first line, I absolutely agree. And what sometimes what they do is extremely important, and the matter would come to the higher courts only on an appeal. But some of this can be counterbalanced or offset by ensuring that in the first 2 or 3 or 5 years for a civil judge or a magistrate, you're not giving them assignments. For example, used to happen in Delhi for a very long time, as I said earlier. You'd have check dishonor cases, compoundable cases, bailable cases, injunction matters, or recovery matters, pure simplicity recovery matters, or a motor vehicles assignment. Some of these were given to just get them started for a few years and learn, and then be given bigger responsibilities. So and some of those solutions can be explored, including maybe mandatory practical work with the legal aid clinics across the country that they can do, maybe right after they get selected, and they may be asked to do that mandatorily, which they'll be able to give back. They'll be able to gain some practical knowledge in the process. Some of that can be done. Now, coming on to the second part, or the question of parity, uh, I don't think it's desirable to have parity at the civil judge or the district judge level, because then you won't be able to differentiate, and you'll end up making the civil judgeship or magistracy a lot more unattractive than what it is. Because then the same person with the same experience would go in for a district judgeship in that sense. And while I agree with Prashant broadly on how it happens elsewhere in the world, the point of distinction may be that things are very different. India has a very unique problem of the dubious distinction of having 5 crore cases, for instance, which are pending, and the kind of sheer numbers that they have, and all of them are not cases which require very very deft or nuanced legal reasoning. Some of them may be very very simple matters, not having grave implications on liberty and lives at all. So you also dealing with sheer numbers. And in my experience, and again, I must add this caveat, my understanding is only experiential and as a user of the system, or as somebody who's been there, and not based on evidence or empirical studies, right? So I've seen that when you're dealing with such numbers, and you're dealing with numbers, a system that is aging, which is not moving ahead with the times, either on the technology side, in smaller, relatively low stake disputes, having a young, idealistic, more technocrat individual who's ready to learn on the job, put in the extra works, is always more helpful, because they're simply able to do a lot more in some situations. Also, I must also add that a judge's role, at least at the magistracy level, is not just pure adjudication. Sometimes, we as magistrates had to go and record a dying declaration at a hospital somewhere, or we had to go do a test identification parade. So a lot of administrative work as well, whether with legal clinics and others. And some of this youthful energy, and this is somewhere also at par with how a young IAS officer gets the service, or an IPS officer gets service. And they have a lot of public dealing, and they have a lot of responsible decision making as well. So when some of these things initially that young judges have to do, I think the relative youth also is does help. But again, equating the experience for either district judges and civil judges, or a reliance on how else it is done in the world. For instance, if you, for example, talk about a UK district judge or a US district judge, sometimes you have day-to-day trials running there. You can finish one trial in a matter of 7 days. The judicial workload is a lot less, and there maybe you'll need slightly different sort of skill set or a demand. So again, I mean, I'm not really qualified to make those comparisons really, but some of these perspectives may be kept in mind.
Right. I would also like to pose this question to the two of you. There hasn't been any parameters set when it comes to this experience certificate that is warranted, right? They haven't specified whether it'll be based on number of appearances in case, where you appear in both civil and criminal matters. Absolutely no specification. How do we ensure that these applicants actually gain this experience and it's not a mere formality? We know how the system works. I mean, if I know any judge, a family friend of anybody, I mean, I can just go to him and get a certificate of experience. So how do we really ensure that this happens in reality? Mr. Chug, if you could go first.
Yes, this again leaves a lot to be desired because of, as you rightly said, there it would become a formality. People, on the basis of their access, may get those certificates. This is absolutely actually no way to ensure somebody's done actual work in advocacy and the practice of law. If at all it is based on documentation, then there may be insistence on a more structured digital diary, for instance, where you're actually giving order sheets where you've appeared in matters. If there is, submission of sample work in terms of the briefs, the memos that you've drafted, the matters that you've done along with your senior, and there should be some way then to put them on a portal and for them to be verified. A mere certificate would, just lead to this becoming an empty formality where some people are able to, work around, and I don't think it would be a solution at all. It would further become exclusionary. As you said, there's so many people who would not have access to people in the profession, may not be able to get it. For instance, somebody in some part of the country who's working with the senior, and then the senior who's not even paying minimum wages, by the way, would again there may be a break in the relationship, and then you start working somewhere else, and these people may find it extremely difficult to even get these certificates. So that it becomes exclusionary. It encourages misuse. Also, it is vague in the sense that it does not define what happens to candidates who may be working in a PSU, for instance, or having an in-house position, or somebody who's maybe working at a firm but not in a litigative capacity. So and while they are still engaging with the law. So some of this also, while there is a carve out only in the favor of law clerks and lawyers, this part also needs to be, I think, worked upon and nuanced further.
Right. Mr. Reddy, do you agree with these concerns?
Yes, I mean, I don't think this is going to work at all. It's been very poorly thought out, and this is what happens in all these Supreme Court PILs on judicial reforms. You usually have an amicus who's a senior advocate who's generally poorly prepared. He makes a harebrained proposal to the bench, and the bench just incorporates it. If this was done democratically and there was a public comment process where all of us could participate, we would have told the Supreme Court this is a poorly half baked idea which should never have been implemented. Because, see, there's also a practical problem here. If you see how most lawyers function in India, when a junior lawyer, like when a young law graduate joins, he's not entrusted with anything more than getting an adjournment for the first 3 years, right? So, how do you expect the poor guy to really get any experience? And that's also telling, right? I mean, in the private sector, you will send a 24-year-old only to get an adjournment, and the moment, and you're still ready to let him get onto the bench and decide matters of life, liberty, and property of people. So this is not going to work at all, and it's also, I must point out that the constitutional impropriety of this entire exercise, because the constitution very clearly vests this power of deciding qualifications with the state governments in consultation with the high courts. The Supreme Court has no business misappropriating these powers for itself. It has been doing so since 1990 or 1991 with the first all India judges cases, and it has made a series of poorly considered, ill-informed decisions, and the trend is just continuing. The only way for the Supreme Court to resolve this issue is to step back and say that we are not going to decide these issues anymore in a courtroom. It is up to the state governments to take up the lead with the high courts and lay down what the qualification requirements should be.
Mr. Chuk, do you agree that this judgment is an instance of courtroom policy making and that it should be avoided so that you actually have reforms which help the system? They are well thought of, stakeholder consultation is done. Do you agree with these concerns?
Absolutely. Courts are hardly the place for, cool, dispassionate, evidence-based thinking and results. You need to consider evidence. You need to look at, for instance, the quality of judgments over the years. You need to see the kind of complaints that usually come up against a young officer versus are those complaints not equally entertainable or entertained usually against more relatively experienced officers or not. So somebody has to really dig deeper into this and look at data and evidence and then decide. And this conversation also cannot happen and should not happen in the context of only civil judges or magistrates, for instance. You need to look at judiciary as a whole. You need to look at district judiciary as a whole, or district judges, and because they're all part of the same scheme and system, and then look at incentives, then look at what kind of talent are we attracting or not attracting, are we retaining it, are we giving them assignments which are stimulating enough. There are so many things, and those are the questions that the court usually is not either equipped or is able to give proper consideration when it is just sitting in a jurisdiction like that.
Right. Now, coming to the point of whether the district judiciary will still be able to attract top talent, we know that anyway, judiciary exams are not the priority, especially for law graduates graduating out of NLUs. And there is also not no clarity when it comes to the career progression. Right. When we look at the higher judiciary, majority of them are elevated from the bar. So, do you see that posing a big problem, Mr. Reddy? If you could come here first.
See, I mean, from what we know from the data, because I've seen this for the Delhi Judicial Services, which is the entry level for which is a service that has civil judges and judicial magistrates. Approximately 20,000 people wrote the exam, I think last year or 2 years ago. And when it came to the Delhi Higher Judicial Services, which is for the district judges, I think only 2,000 people wrote the exam. So, I mean, that's also because, people are at different stages in their life, because the minimum qualifying age for the Delhi High Judicial Service is 35 years. So at 35 years, a lot of people have settled down in practice, etc. They don't want to make that switch to the bench. So, yes, I think as qualifying ages increase, the number of people who want to sit and write a judicial service exam will, it is going to, the pool is going to be smaller for sure. And like Bharat pointed out, if you're going to maintain the same kind of package, which you have incentives and pay package, which was designed, say, for a 24-year-old or 25-year-old, and you expect them to have the same thing at a slightly older age, it may affect uh, people who are joining the bar, sorry, the bench at this in this particular office. But honestly, I don't know, because there is an increasing clamor for joining these judicial service offices. Like it has, like, I mean, just look at this, the number of coaching institutes that have opened and what they're charging. It is a lucrative business, which means they have a lot of people willing to join this particular office. So I think it's too early to tell. My guess is, given the oversupply of lawyers, there will always be people who are willing to write this exam in India. That's my guess. Then you're not going to have a shortage of candidates. Are you attracting the best candidates? That also depends on whether you think a written examination is the best way to select judges. A written examination, even combined with an interview. Because I happen to have strong views even on that. Because there was a time when, for district judges, for example, like, interesting anecdote we narrate in our book also is about Justice HR Khanna, the famous dissenting judge in the ADM Jabalpur case during the emergency. He started off as a lawyer practicing before district court, and he became a district judge. He didn't have to write any exam. Basically, at that time, they used to invite applications. They would see your experience as a practicing lawyer. There would be an interview based on your experience, and then you would be selected. Because if you're making the practice requirement as one of the main criterias, then all you need to do is to assess a person's practical experience, right? In which case, a written examination really doesn't make any sense.
Right. Mr. Chuk, what are your thoughts on this? I mean, how do we really incentivize young law graduates to take this exam, especially after this practice requirement?
Right. So I think you'd still have, completely agree with Prashant, with the sheer number of lawyers, you'd still have a lot of people wanting to give the exam. And that's for a number of reasons. One is that a lawyer who's not from one of those top law schools sees this as the only level playing field or an opportunity to make a difference where merit, so to speak, and that's the belief, really counts. And then you can, even if you don't have access, if you don't have a strong alumni network, you can still contribute to the system while also having some sort of a job security. So it still would attract a lot of people. And some of these do really want to be judges, they want to make a difference. But yes, there would still be a lot of people, as Prashant rightly says, who are there simply because the practice of law is full of struggle. And that's a difficult life in that sense, and law is a marathon, not a sprint, right? It takes forever to build a practice. So some of them would take the exam also for that reason, and that's hardly ideal. Nobody should become a judge really because the practice of law is difficult. So you'd always have people with all sorts of motivations and incentives, right? But and you'd still have a lot of people, but again, with this 3 year requirement, and I said the 3 year practice requirement effectively means that you postpone your preparations, then you prepare, and it would effectively mean that you're entering the system 6, 7, 8 years after you've graduated. And people who think they can, excel at the practice of law and do excel at the practice of law in that time may not want to then come back and start off as civil judges and magistrates, because you'll have to remember, that even uh, the work conditions or the service as it is currently, there's a lot that we really need to work on. For instance, the portfolios that judges sometimes get, the sometimes the promotion avenues are extremely limited. Work conditions, we look at Delhi, but if we look at elsewhere in the country, some of these judges really work in very difficult work conditions away from their families, in very, very remote districts, and it's really a service. So some of those obviously would have to be worked on in order to attract the best talent. But and you'd still have a lot of people take the exam, but I believe that you'd lose out in terms of really attracting the people who can make the most difference to the system.
Right, and Mr. Chug, adding to that, a common apprehension that I have seen in my juniors as well as batchmates is that in most of these states, especially, these judiciary exams are not conducted on a regular interval. There's also, and even if they are conducted, the results are stalled. There's so much of litigation around these exams. You have so many irregularities in these exams. So, do you think these also pose as a barrier when it comes to meritorious law graduates taking these exams?
Absolutely, absolutely. There has to be more certainty to the process so that very serious candidates are able to plan, maybe on the lines of how the civil services exams are, conducted. There's a lot more uniformity. So that's important. Also, I think we really need to take a look again, and this is not just in some of the states, it's a pan-India problem that you need to really think if the current examination pattern, even with the interview, is sufficient enough. Now, obviously, you need to have some way of checking an appointment on a candidate basis, for instance, because, for example, you've seen somebody in court is obviously full of, subjectivity and open to, arbitrariness. So you'll have to have an exam, of course, and interview. But again, what is the content of that exam? I've seen or a heard of judicial services exams where you are sometimes asking questions of the British Constitution, but not really from the Indian Penal Code. There are examples such as that. So we need to, on an all India level, take a relook and reimagine what is the content of the exam, what is the syllabus. Interview also find out a way to really check the soft skill of the candidates. Their patience, their ability to deal with people, their EQ. Some of this obviously is very difficult to measure in any exam system or any interaction, but some of those softer aspects should also be captured somehow in the examination process to make and attract better talent.
Right. In the recent couple of years, we have seen a better gender ratio when it comes to the district judiciary. A bit of statistics for our listeners here. The recently published India Justice Report revealed that the overall share of women judges in the district judiciary increased from 30% in 2017 to 38.3% in 2025. Mr. Reddy, coming to you here, I mean, of course, you've mentioned that you do have reservation for women, but do you see this particular judgment kind of slowing down this progress in gender representation?
See, so there's an interesting paper on EPW by my former colleagues at the Vidhi Center for Legal Policy, I think by Sumati Chandrasekharan and a few others. So what they pointed out was that while the number of women in the lower judicial services, that is the civil judge, judicial magistrate, has been increasing, the same increase wasn't reflected at the level of the district judge, because district judge has a 7-year practice requirement plus, and like I said, that it's de facto, it's actually a 20-year practice requirement. So there's this discrepancy even within the district judiciary. And I'm not sure, I think one of the arguments that they do make is that it's perhaps the practice requirement that is, making all the difference in women joining, the representation of women at the district judiciary level and at the civil judge judicial magistrate level. So that is one theory, that the practice requirement will affect the intake. But also don't know the number of women who were sitting for the exam and clearing it. So we don't have enough data to answer a lot of these questions. But the general hypothesis is that, you know first three, like, expecting women to practice for 3 years is going to be difficult, because a lot of them, if they don't have a stable source of income, etc. There is pressure to marry, settle down, etc. So if you allow them to join the judicial service earlier, they have an independent source of income, and that also increases their autonomy and how they, deal with. They can resist and delay marriage and have more control over their careers. So that's the argument. But as long as there is women's reservation, and it is seen to be a lucrative avenue for employment, I think you will see women. The increasing percentage, also, what we need to understand is this increasing percentage of women in judicial office may also be an increasing reflection of more women taking up law, and you have a booming middle class now which sees law as, as a profession where you as a respectable profession where you can make a good living. So there's a study even on participation of women in private law firms, private corporate law firms, by I think it was a PhD study by Shweta Balkrishnan, I think her name is, where she's shown that it's remarkable, the representation of women in corporate law firms at partnership level is quite remarkable. So compared to generally corporate India, etc. So I think there's generally increased participation of women in the legal profession is here to stay, and reservations will ensure that they still have a way to get into the profession. So I don't think the number of women participating is going to reduce, unless they use tactics like saying no suitable candidate found, which we've seen they've used in the case of SCST candidates in a lot of government institutions. But I don't think this is. But I don't think women are going to go anywhere, especially from the middle class. Women now see the legal profession completely differently, and they are here to stay.
Mr. Chok, do you agree that there isn't going to be a considerable dip in women representation in the district judiciary?
I think there would be an impact, and women would be disproportionately impacted. We had made very good, progressive strides in terms of women representation at the trial court level. For instance, in the last few years, you've had 60% or more at the entry level judges being women, and especially the top ranks. For example, 2013 is when I took the exam. Amongst the top 10 ranks, I think we had about 6, 7 of them were women. And in the last few years, you regularly see exams being conducted where out of the top 10 rankers in an exam, 8 are women or 7 are women. So this, it was a very, very good trend, and we hoped that it would continue. And then even at the district court level, because many of the district judge posts would be filled in by people who enter at entry level and are then promoted, right? So we hoped that it would impact there, and thereafter at the high court and probably at the Supreme Court, where currently the representation of judges who are promoted from within the service is relatively less. So it was a very, very healthy trend, and I think they would be impacted. Unfortunately, the current state of the legal profession, with how unstructured and full of privilege, and there's a lack of diversity. There are so many entry level barriers with women entering, especially if, for example, if you're from a relatively conservative family may be reluctant in having you litigate. They probably want you to go maybe a corporate law practice or go into academia. But even if the girl in question wants to practice law, there would be reservations from the family. And now with this 3-year practice requirement, they'll be either compelled to take up something else, or simply not pursue this line at all. And I know fantastic young female law graduates who've always wanted to be adjudicators. And I come back to the same point, they've never thought of law as wanting to argue cases. They wanted to decide cases, listen to them patiently and with compassion, and decide them. Now they may not be able to pursue this line at all, and would ultimately impact the system as far as diversity is concerned. And the way trial court judgeship was turned out to be a massive equalizer is going to take a hit. Yeah.
I'd like to now end this discussion with your concluding thoughts, primarily on, in the future, how do we really measure the success of this reform? Will it be through the conviction rates? Will it be through the grant of bail in personal liberty cases? Or will it be through public satisfaction? How do you think, how do we measure the success, if at all, of this reform? Mr. Reddy, if you could go first.
See, I don't think there's any objective way to measure it. I mean, a good measure, I think, would be is if there are less complaints from the high courts and the bar councils about the attitude of these young lawyers who are appointed as judges, because the consistent complaint has been that they are not polite enough and courteous enough and mature enough while dealing with the bar. So I think if the number of complaints on that factor reduce and it reflects a greater confidence that the bar have in the bench, I think that would be a good enough indicator that this reform is somewhat successful. Although I still think the Supreme Court's prescription is being poorly thought through.
See, I think you can measure any progress only once you have a sense of where you began from, right? And this brings us back to the basic point of what data do you have today, what evidence do you have today. You'll be able to measure and compare what happens 5 years from now only when you have a starting point, right? On the issue of whether they are less complaints and whether that is evidence of the system improving, I have my reservations on that. I don't think a complaint, and sometimes these complaints may be absolutely unsubstantiated and sometimes filed only because a judicial officer is not granting, for example, an adjournment at the drop of a hat, or is pushing back against the abuse of process of law. And when you are doing some of those, you sometimes have pushback in terms of a frivolous complaint on your conduct or something. And most of them actually are without any evidence or any affidavits, and sometimes they are just filed with a view to get the judicial officer to fall in line and not try to do something which would help the system, which is progressive, and just have the judicial officer become conformant and a status quoist in that sense. So I don't know if the number of complaints or the lesser number or a greater number is going to be able to help us to measure. I agree with Prashant. It's not well thought of on how we do this. And another thing is, you've had some states, and I must say this, you've had some states where you've had a a 3 year requirement or some practice requirement. What would have been good to see is a comparison of those states vis-a-vis the other states, where you take judges at the entry level and then see what difference does it really make. So I really have my doubts if anything would be able to help us appreciate improvement, if any, from this proposed reform.
Thank you, Mr. Chugh. Thank you, Mr. Reddy, for such an insightful discussion. This brings us to the end of this episode. Thank you so much for joining us.
Thank you. Thank you for having me.
Thank you.